Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday, so we have 2 streams today. One this morning and one later at 8 o'clock. So, that'll be fun. We're going to stick to Indiana today. We have a couple cases from Indiana. Here we go.
The probation.
That's correct, Your Honor. My client was released on an ROR plan, and probation actually filed a progress report on this. He wasn't able to get checked into his treatment because he tested positive at the time for Suboxone, which he had previously received in jail. Probation is not asking for a warrant on that progress report, and I just want to draw that distinction. I have another case that I also received a progress report this week, where they are asking for that for something similar. They're not asking for that here. I've talked to them. We're trying to find an option for him that's going to work for me. It's a safe place to stay right now, but we're kind of having to adjust the plan. And so the probation wanted to file that with the court, since technically speaking, we are kind of off the ROR plan that we were on right now. But I would just ask the court's forbearance while we try to work this out a little bit.
Well, these joint agreements never work. They never, my experience has been, they do not work.
I've done many of them, being one of the primary drug court prosecutors. This one's a weird one. I've never had one like this where someone is on medication assisted treatment in jail and then Life Treatment Center turned them away. We have been having trouble with Life Treatment Center recently. I will note that. But I've never had anything like this in particular happen before. My client is staying clean, and he's continuing to draw while he's out.
It said, the agreement said, if he fails to reside at Life Treatment Center, fails to meet Amanda Van Hall, is scheduled, fails to appear at the drug court hearing, the court will issue bench warrant. He
did those things. He showed up to go
into reside in Life Treatment.
And Your Honor, it's not by any fault of his own. It had been 2 weeks since he had taken Suboxone. It was still in the system, and they refused to take it. It's
actually, no. I was staying in the Life Treatment Center, and I had went and got my script from Oakland, like they had asked me to, and then I gave them my script. And the last day that I took it was the 26th, and they had discharged me because they're saying that I could be buying Suboxone off of the street from somebody else, and I was even questioning myself, like, I mean,
yeah,
I don't know why they kicked me out.
Wait a minute, but with all due respect, sir, you had an agreement. I expect you to honor it.
Yeah.
You're not honoring the agreement. I don't like these joint motions to release somebody, because especially with
I've been doing everything I'm supposed to. I've been going to.
Well, if you were doing everything you're supposed to according to this agreement, I wouldn't be reading this report about how you didn't follow through. So how much grace should I grant this individual, sir? How much grace?
Your Honor, what I would say about the reason why I push for these agreements and why drug court is something I do push for clients like Mr. Barrett is because it's one thing that seems to actually work. And we do need to understand that there's more grace than is normally required in criminal cases to get them through this, because we're dealing with a medical issue.
I get it, but he was released. So the next time we come back, he doesn't do anything. I'm supposed to understand and nod my head and say, gee, I hope we weren't too harsh on you, because you decided you wanted to do this and you were supposed to follow certain conditions, but gee, you got a problem, so we'll just let you, whenever you're ready to do something, we'll do it. So I'm going to let you come back, but my patience is over.
Understood, Your Honor.
Because, sir, you signed an agreement, and I expect you to honor that agreement. If you can't honor the agreement, then you go back to jail.
Yes, sir.
So now what are we going to do?
Well, Your Honor, we are, as I said, we are trying to work our way through find a treatment solution for him that will work, and we are still working at this point towards drug court placement. So at this point,
What does that mean? I mean, he's got no place to go for treatment. Yes.
He's inpatient treatment, Your Honor. So we're looking specifically for, he is receiving treatment and he is testing, but he is not in inpatient, which is kind of the first step that we want and need him to take as part of this treatment plan. So that's what I'm saying when I'm saying we need to get him into treatment. So we want to get him kind of in a reset position in inpatient as we work towards.
All this held together. When's this all gonna happen?
Your Honor, if we could be set out about a month, I think that we should have some clarity on what's going on right now, but I understand with this report, if the court wants to set this out a little bit sooner, I would completely understand.
Except for March 16th. Can you do that day?
Yes, Your Honor.
So, sir, let me tell you something. I expect you to honor this agreement. I expect you to be doing some sort of treatment. I expect you to follow through with probation. I had probation to provide me with a report by the 13th of March. And if you're not following through on things, I don't care what your lawyer says, and that you have a condition that we all need to understand, you go to jail.
Yes, sir.
March 16, 9 o'clock.
Thank you, Your Honor.
You need to go up to check it with probation.
Yeah,
I'll take it.
Yeah.
Embarrassing.
He's reporting to probation then, correct?
I'm, without objection from the state, I'm moving for continuance of the trial. Mr. Walker has historically had good communication with me, but he's recently had some difficulties financially and with his phone and kind of fell off the radar over the last month or so. Only recently got back on and advised me that he has some witnesses that he'd like to call for trial.
Ain't too bad. You know, I mean, sir, how old are you? 22 years old. This case has been pending since July. We had a record date already. I get that we had a record date already. You said you're ready to go to trial. So you know what I think? I think this is just foot dragging.
Well,
Well, when was the first conversation about these witnesses, which I'm guessing I won't see?
I just got my phone back.
Oh, the only way you know about these people is by having a phone. You don't know their names.
Yeah, I know that. I got.
You know their names.
Yeah.
You know where they live without
Yes.
the phone.
Yes.
Well, then I don't think the phone cuts it. So why did you supply that information to your lawyer?
I didn't know that I can bring witnesses personally. I didn't know that.
Oh, sir, you're advised that when you're arraigned, you're advised that you can use the court subpoena power to have witnesses come and testify on your own behalf. Now, if you didn't listen to that, that's on you.
Understand.
So,
he does have that. I mean, I know it's late, Judge. I'm not trying to
Well,
mitigate that, but he does have that
but see,
constitution.
this happened last trial we had, this last minute, I need a continuance because I don't know what happened in the last case, probably because the state had introduced some late evidence, but now I'm being told that your client hasn't even communicated to you about witnesses. And so, sir, at some point in time when you're an adult court, you have to act like an adult. Now, if it were me, and I had witnesses that said, hey, whatever they're saying happened didn't happen, I would have been on my phone. I would have walked to my lawyer's office and said, hey, here's these witnesses you need to talk to. Here are their names. And then I'd hunt down where they lived if I had to. But you didn't do any of that. I don't have anything from the state saying they don't object.
I've got a text message from Miss McKinney and she
You
emailed.
know what irritates me, sir, is that I only have finite, this is foot dragging. And I'm going to guess that I'm not going to see one single witness that you supposedly have that's going to testify on your own behalf.
Well, I won't know that until I have.
Well, you won't know that, but you know what? If he doesn't want to take advantage of his lawyer and doesn't want to communicate with his lawyer, then that's on him. That's on you, sir. You don't want to take advantage of your lawyer, You come in here at the last minute and say, gee, when you saw Mr. Dixon on your record date, did it dawn on you that you had witnesses? And why didn't you tell Mr. Dixon, listen, I don't have my phone, although we've already learned that you didn't need a phone because you already knew the names of these witnesses and where they live. You didn't say a damn word to Mr. Dixon because Mr. Dixon would have told me on the record date, hey, Judge, my client has just told me he has these witnesses. I don't know who these guys are, who these people are. I need time to do this. I need a continuance. We've already called a jury. We've already done the work for a jury. This is foot dragging. That's what it is, sir. It's not a legitimate request on your part. You have a note from Ms. McDane?
Judge, she's indicating she's not objecting. I don't want to be put in a position where we're going to trial with witnesses we know about this morning.
Well, I will bet you that we won't see any of those witnesses. No, I don't think so, sir. I think that's all BS. And if it's true, and you do call these witnesses, then I guess I'll stand correct. But I don't think we're going to see those witnesses. CR 4 times on you, sir. If you come in here again, Mr. Dixon, make it very clear to your client, I don't want to hear after. That's why we have a frickin' record date. So people can say, hey, I'm not ready to go to trial. You play games all you want, sir, out of this courtroom, but you don't play games in this courtroom, and that's exactly what you're doing now. How long would it take you to get these mythical witnesses?
I think I'm going to instruct him to have their names and phone numbers to me before this.
Oh, he doesn't even have the names and phone numbers for you yet?
A hooker bar.
I have the names. I just don't. It's in my phone, so I wouldn't be able to.
You don't know where they live, right? Right? You don't know where they live?
2 days, Judge, is what I was going to say.
2 days. I want to have the trial on Saturday. I'm not going to be here.
No, to instruct him to have those witnesses made so that I can chase them down and share them with the state.
You're a 4-time defendant. Don't come into my courtroom, sir, and tell me you're ready to go to trial. Because right now I think you're playing games. Call the jury off.
Call the jury off.
And if we come back on the record date, and in between the record and trial date, I hear, oh, wait, I've got somebody who's living in Europe who's going to come over and testify on my own behalf. Forget it. This is your last shot, sir. Take this seriously because you can do 30 months in jail. And if I decided to treat these cases consecutively, if I was legally justified in doing so, you'd be looking at 60 months in jail. It's time to take things seriously.
Do you think he has witnesses?
April 23rd.
I'm in a public defender CLE that day down in Indianapolis.
April 30.
That works fine, Judge. Ten o'clock start time, correct?
Yes. Record date's April 9. Oh, are you out of town April 9? You say you're out of town April 9?
Me?
Yes.
I don't think so. No,
Thank
I'm
you.
here.
Thank you.
This meeting is
Thank
out, but I'll cover the rest.
I would see you have something covered already. Record date's April 9. Well, Mr. Walker, if you come in here April 9th and say you're ready to go to trial, I'm gonna hold you to that. I'm not gonna take any more BS about how you've got some late evidence, because now's the time to get off the chair and start working on your case. And if you don't show up on April 9th, I'm gonna confirm the trial even though you weren't here. You understand that? And I'm gonna issue a warrant for your arrest. I want you to answer audibly for me, sir.
Yes.
I think we're watching Judge Francisco. David Francisco from St. Joe's County in Indiana, I think.
The trial date's April 30th. And plan on going to trial on April 30th. And if you don't show up for court for your trial on April 30th, we'll try the case without you. Do you understand that, sir?
Yes, Your Honor.
Did you get a reminder of your court date?
Yes.
Sheriff, work time for your defense. All right, sir.
Thank you, Jeff. Oh, sorry. Okay.
If you're anyone else waiting to go in front of this judge right now, are you? How do you feel about your case so far?
You say the back text and Jim's.
He's just yelling at everybody.
Yeah, at Brianna Jackson.
Brianna Jackson? What are we doing, Miss Jackson?
I would just ask for actually a pretty quick status date. I want to reach out to the state and make certain I'm getting at least a better understanding of what the violations are and speak to my client. And then I think within the next couple of weeks, we should tell the court if we need to evidentiary hearing if there'll be permission.
But isn't it a the Cleveland County placement
It
violation?
is.
Like I said, a zero violation, zero tolerance behavior contract she violated.
Yeah, I can't, I mean, they attach a violation, but it's not signed until January 2nd. And a lot of what they put in is before that. And some of the, I guess to be clear, I've read words on paper that sound like it's a pretty heinous violation, and we get the allegations themselves, and it's relatively innocuous, and I'd like to investigate which side of the fence these are on.
Well, are you talking about, there was a report filed on 116, did you read, you saw that report, did you not?
Yes, I have that report. I just want to give more details on what it means to be out of place.
Okay, well, how long do you think you need to investigate all this?
I get just 2 weeks. I think I can get this information to stay pretty quick and speak with my client. And then at that point in time, we can clear out if we need an evidentiary hearing. I mean, alternatively, we can set it for an evidentiary hearing. And if I need to come in before that, I can.
Okay. That was interviewed on the 27th of February. Can you do that day? Friday?
I am now.
And if you can work it out, you can come in anytime.
Yes, sir.
All right, that's it.
Thank you.
Yep, see you on the 27th.
Great, Your Honor. That's all I have. Thank you.
Norris.
Mr. Gandy.
What are we doing, Mr. Gandy?
We're set for sex either day, right?
Is on a probation, revocation, right, admission.
Yes, sir.
So. Your recommendation, sir.
Your Honor, Mr. Gandy has the two cases, and he's still got a lot of time hanging over his head. And we've discussed that. I understand that. If I could recall the court, the reason he wanted to get these PTRs settled and handled is because he's got an Elkhart case and he's looking at a community corrections option over there. I do expect that this court is going to execute some time, but what I would ask is that one of these cases at least be used as still a suspended sentence to put him back on probation, to allow him to have a transition out of that community corrections situation in Elkhart, and to allow that extra supervision. So that would be our request, Your Honor.
All right, state.
Okay, I don't get it. I try to get it. So, I don't see anything wrong with this courtroom. I like it. I like the carpet. I like there's no wall art. I like it's functional. You go in here for court and then you go home. I like it. I don't know. It never crossed my mind once. I've watched this courtroom so many hours for 2 years now. Never crossed my mind once that the carpet was ugly. That this courtroom is horrible. The acoustics are horrible. But this is why I am never in charge of decorations ever in any situation, because you know what? I can't find better courtrooms, Bren, because I don't notice things like that. I notice the judge. I notice the defendants, but I don't notice the aesthetics of a courtroom, except for Hell Court. I did not like Hell Court at first, and now I miss it because it's gone. I'm ready. I'm in my email now, waiting. I sent you my email, in a direct message in Discord, and I'm ready. I'm ready. I bet they're going to be awesome.
Judge, I can't overlook the fact that it appears that,
Hey, sir.
Judge, I can't overlook the fact that it appears that the defendant has violated probation in 1, 2, 3. I think this is the 4th case in the past 5 years or so. So federal supervision when he was sent, federal and state supervision when he was sentenced in this case, placed on probation, while on probation in 2 cases, he has a new offense out of Elkhart. And given the series of new offenses and series of failures of probation, imposing the executed or suspended sentence is the appropriate.
All right, sir. Mr. Gandy, anything you want to tell me?
Your Honor, recently I just had a newborn, 3 weeks ago, and I've just been really been making poor choices. Also, I understand I hold myself accountable for those choices, those wrongful choices that I made. And really just want to grow. I just want to be a man. Just grow up. I've been making the wrong choices, and I just want to tighten up. and get my things together. 30 years old. I have another child that just turned 10. Just want to get out and make the right choices, man. I've been incarcerated in Elkhart. I've been going back and forth from here, which due to my poor choices, back and forth from South Bend to Elkhart, just to deal with these allegations. And I just hold myself responsible for the choices I've been making. I just want to tighten up and just get these things taken care of so I can get back out society and do the right thing.
Sure. Well, in 153, when you were sentenced, gave you a suspended sentence, gave you an opportunity to right the ship, so to speak.
He said ship,
I
people,
think you
ship.
might have been on. And then I continued you on probation in 17. So your lawyer's basically telling me I should do the same thing I did before. And I'm not going to do that. They did give you an opportunity, sir, and I appreciate that you want to turn things around. Give me that opportunity. But it doesn't look like. Doesn't look like that's happened. Maybe it'll happen in the future, I don't know, but I'm not willing to take a chance on that. That's this point. Given that I didn't take a chance before, so to find my notes. This. So in 71 D03 1801 F5 17, we're going to impose the original, I think it was 24-month sentence to the Department of Correction. You have you have 38 days Class A credit. That'll be applied. That'll be consecutive to 71 D03 2305 F5 153. Where the sentence will be 30 months, and you have that report. You have 30 months executed, and you have 122 days Class A credit in 153. That would be consent. That would be the sentence, sir. I'm not going to assess the PD fee.
Was this a case where probation was revoked, not placement, right?
Right.
Okay.
Hey, sir. You have good conduct in the Department of Correction. Want to send me a note about that? Not next month, or not 2 months from now, or 3 months from now, 6 months or more from now. I'll take a look at it. Okay.
Get that GED too. The one for Tennessee, okay? So they're probably gonna send you back to Elkhart to sort that. And once you get that sorted, they'll send you to DOC to do those, and then you can do whatever, right? That's really okay.
You guys want to talk out in the hall?
Yeah, sorry, Judge, sorry.
Stop wasting the
Yeah.
judge's time. Oof, stop it.
Rashida Gonzalez. Yourself in the same spot that the last person found themselves in that this is a probation revocation. They're alleging that you have a new criminal offense. I'm guessing that the case's gonna be transferred up here.
I think it needs to be transferred to the 11.
Has it been transferred?
It has not yet. It's in front of Judge Early at the moment.
Okay. So, let's contact Hurley and we can give them a court date.
Judge, I'm sorry, who is this?
This is Reginald Harris.
Harris?
I have the cause.
Hang on just a second, sir.
I have the cause number of the meeting.
Okay, what is that number?
71 2602 F6 100.
100?
Yes.
Okay, Judge, you want that case transferred here?
Yeah.
Okay.
Do we need to notify them of that? Or
We transfer it and send them an email.
All right. So, I would suggest that maybe we set this over to next week.
I have no objection.
That would be by February 18th. Yeah. On both cases. Hey, sir, have you been in front of the magistrate on this other case?
Yes, sir.
Okay.
I currently have a bond, sir, but my problem right now is that I'm on a probation hold for this matter. Well, I'm in the middle of the court now, and what I'm asking is if I can get a public defender appointed, and I will also like for my probation hold to be lifted, and which I'm asking for an OR so that I could post the 1250 bond. Because that is all I have. That's all my family has. That's all that was put together. I had no idea that I would even be facing a PTR for allegedly things, but all this is new to me. I'm learning it as I go through it.
Well, so one of the conditions of probation is not to commit any criminal offense.
I didn't, sir.
Okay, well, that's fine. That's why we have trial. So I am going to appoint a public defender on both cases. Your next court date will be February 18.
My court date was February 19, sir.
Well, now it's February 18.
My question is, can my probation hold be lifted today?
I haven't forgotten what you asked, but I'm taking care of this first. What was the bond you had to post in the felony case?
They want $1,250 for
1,250.
Yeah.
And you say you can afford that?
That's all my family has. That's all I have. That is it. And if you could lift this hold off me today, then I can not only post that bond today, I'll be one of the first people in your courtroom on the 18th to be trying to get these matters taken care of.
Yeah, I'm gonna be here early. Make sure that's true.
I'll be here at 6. You want me to bring you
Can I get
back?
a witness?
Can you cook?
I can bring Burger King through for 5.
No, that's all right. All right, sir. I'm going to release you on your own recognizance on the probation revocation. You still need to post bond in that felony case. Your next court date is February 18th at 9 o'clock. That's next week. That's when you're going to meet your public defender. You do not need to come in at 6 in the morning because nobody will be here. Come at 9. I'll be happy if you do that.
Can you please lift my probation hold?
I just vacated your the warrant, sir. I just did. Did you hear what I said?
I just took some blood pressure medicine.
Okay, well, I vacated the warrant, meaning the warrant has been lifted. that you can bond out, come back to court
Right now?
next week. I don't know, sir. It's not right this second, but yes, you'll be able to get out. If you have the money, you'll be able to get out today. Post the bonds, okay? See you next week.
See you there.
All right.
Thank you for me now.
Ms. Campbell, you're not working, ma'am?
No. No.
How long have you been laid off? For 2 years and you haven't found any employment since?
No.
No, you haven't?
No, I haven't.
Well, how do you pay for your housing and food? And how do you do that? Your husband? So what's your husband bring home a month? You don't know? So you guys never talk about how much money your husband brings home, huh? No? All right, ma'am, I'm gonna appoint the public defender pursuant to IC 353376C. Your next court date will be March 10. March 10, we'll give you a reminder at 9 o'clock.
Amen.
All right, see you then. March. Well, Mr. Reiner filed a motion. Motion withdraw, he's not here. Was Mr. Griner your private attorney?
No, sir. I think it was appointed.
Looks like you saw this.
Did I?
I think on the third, the court did orders of draw. Might be saying.
Well, I have an unsigned order here. Oh, wait a minute. No. I'm gonna rescind that order. Yep. I signed an order that I don't remember.
Sorry, that was the note that I had from the deputy I'm looking at now.
No, because I would have done that.
I do have it pulled up here.
But I don't see it. Here's my point. I don't decide who your public defender is, sir. I don't have the authority to withdraw or appoint public. I can appoint a public defender, but I don't decide who. And I don't know why I would have signed that order because he was your public defender. So you don't want the public defender to represent you?
I wanted to hire a lawyer.
Oh, all right. So much time you need to do that?
Like 90 days, but I need a bond reduction also. And I was asking, the provider here gave me medication. So I was asking if you could lift the mental health evaluation so that I return to the regular general population and have more access to use the phones and stuff. They only let me out an hour. And the skills are kind of mean. They've been violating my constitutional rights and stuff. I just want to go back to the general population, sir. When I left your court,
How are you going to hire a lawyer? Let's assume that you did get out. How are you going to hire a lawyer? You don't have any means.
I've had 2,000 stashed away myself.
Well,
And I was going to ask you if you can call my sister right now.
no, I'm not your lawyer, sir, and I'm not your secretary.
No, there's a protective order on her, and she would never do that. I don't know how that happened, but I'm pretty sure she
Wait, time out. I'm going to rescind whatever order I said granting, and I'm surprised I would have granted that order because I normally wouldn't do that. Rescinding that Mr. Griner is no longer your attorney. I'm going to set this for next week, February 18th. I'd like to know how that came across, really, to be honest with you.
I think I fired him, Your Honor.
You can't fire him, sir. You can't fire somebody you didn't hire.
Oh, I don't know, he withdrew.
Well, he can't withdraw. He can't withdraw unless he gets the okay from the chief public defender. It's Mr. Kimmel. I don't interfere with the representation of a public defender and his client. That's not my job. Because everybody coming in here would say, oh, I want a new public defender, and I'd appoint a new public defender, and we'd never get anything done. I leave that up to Mr. Kimmel. You have an issue with Mr. Griner, you need to address that with Mr. Kimmel. As far as I'm concerned, I'm reinstating Mr. Griner as your public defender. I will let Mr. Kimmel know there's an issue between you and Mr. Griner, and he and Mr. Griner can work it out to see if he's going to continue representing you. I'll see you next week.
Sir, may I ask, can you lift the mental health evaluation? I already received a medication.
I don't see a mental health evaluation.
I'm in oranges because of your mental health evaluation. You told him last court date to the jail when I asked for medication.
Judge last hearing, the defendant.
Oh, okay, yeah, you said you had back on January 28th, you said,
yeah, I also had a finger bomb. No, I said I needed medication, Your Honor.
Okay, so
I kind of.
you don't need it anymore?
They give me medication, Your Honor. It helps a lot.
I don't know how that order slipped by me. I really don't. All right, sir, I'll vacate the mental health evaluation, your mental health treatment. You won't get any medication though. And we'll be right back to where we started. See you next week.
Thank you, Your Honor.
Yeah.
Can you advise class then?
Yeah.
Yeah.
I don't know what you're vacating.
I'm vacating the order, which doesn't show that I signed it, but okay, everybody's telling me I signed the order. I wouldn't have signed the order if I'd have known he was a public defender, because that's not my job. So
No, I think is this the guy that came and said something about he was gonna like go crazy, and then you talked to the deputies up at the bench? Is this that?
yeah, maybe. Yeah.
Oh, yes.
Somebody?
The order on January 28th. Sheriff to follow up regarding mental health treatment at the jail.
Right.
So you're gonna vacate the mental health treatment?
Yeah.
All right.
But I just don't understand how that would have gotten. How I would have gotten that, right, was that something I need to do with? I'm done with that. I got.
Yes, you've already done that one.
I don't know why I would have signed an order vacating Mr. Grimes. You guys fill out your forms, you done? Yeah, come on up.
So I left that last part in because his coordinator or clerk or whatever they call her in that courtroom is amazing. She knows all the cases, and like you can always hear her in the background when the judge is trying to remember what happened the last time, blah blah blah. She's always like, oh, this is the one, remember he had the blue shirt on, and she knows everything. She's really, really good. Okay, next we're gonna go Indiana, but it's a different Indiana. Oh, it's the same one. Hold on. I just about to show you the same clip again. No more chances. This is it. I think this is Judge Ballbreak. I think. I don't know. It's really early in the morning.
Morning, sir. Good morning. Your cause number is 2508 F453. We're set for sentencing today. Mr. Britton, are we ready to proceed this time?
Yes, Your Honor.
All right. And Mr. Hunt, so normally I would ask if we have any witnesses, but I can look around the courtroom and see that we're the only ones here. So the state doesn't have any witnesses and the defense doesn't have any witnesses, is that correct?
Yes.
Okay, so did you have an opportunity to go over the PSI with Mr. Hunt? Did he have an opportunity to review it and work if there's any errors, Mr. Britton?
Yes, sir.
Okay, and was there anything we need to correct from that PSI?
No, Your Honor.
Okay. Then, what we'll do, Mr. Hunt, is we'll hear from your attorney. He'll make his argument, recommendations, and we'll hear from the state. And then you'll have an opportunity to address the court if you'd like to. Okay? Mr. Britton, the floor is yours, sir.
Thank you, Judge. So I think that it's fair to start with defendant's criminal history, and I think if the court goes back and looks at his adult history, it started with a robbery conviction with an offense date back in 2014. I believe 17 years old of age at the time. And, you know, I think that at a young age, he made a choice that put him on a tough trajectory moving forward. You know, but for that robbery conviction, he obviously wouldn't be here today on this type of case. And really the only other prior felony conviction that was passed also was based upon that prior robbery conviction. But for that, he has a couple of misdemeanors. It's significant. We acknowledge that, but yet, you know, at a young age, he kind of put himself on a difficult trajectory to navigate life. It's come back to haunt him. I think that this case is also the factual, as articulated in the affidavit, is somewhat unique. You know, there are the possession of a handgun charges, unlawful possession of SBF charges, where it's clear the person was engaged in some type of intended conduct that maybe not provable. In this case, he is literally being chased by a different person being shot at. And I think his comment to me initially, like before I got the full discovery, was I was pretty lucky. Because if he had not been unlawfully armed, oddly enough, it may have been a much worse outcome for him. And he and I did have some discussions on, you know, if you live in a neighborhood and in the past you've associated with people that haunt you like this, you got to get out of the environment, because it's a pretty tough life to live where you live in an environment where you feel like you can arm yourself to survive, but by arming yourself, you're guaranteeing future incarceration. It's just untenable. And he acknowledges that, and he understands that.
Where's Bobby?
He understands it. He's got a kid. You know, in speaking with him, he's served a fair amount of time in custody, and I think that he's most certainly employable.
Me too, Nan. Everybody's sleeping this morning. We got a light crowd today. It's a sleep day.
He has skill sets that he can get employment, take care of himself and his family. I think he most certainly does have a diagnosed mental health issues. He went into incarceration at the age of 17. He did indicate that he suffered some abuse while incarcerated, and I don't think he's ever appropriately dealt with that either.
Yes, sir.
With that, Your Honor, we were asking the court to consider either a suspended sentence or community corrections placement that transitions him into a suspended sentence, where he can address the issues that are probably underlying a lot of what's confronting him in life, allows him to get back out, seek employment, and support himself and his family, and hopefully find a place to live that doesn't put him in this position where he gets put in between two intensive circumstances. Thank you.
State, your thoughts?
Mr. Honor, a state notes the criminal history of 3 prior misdemeanors, 2 prior felonies, almost the entirety of his criminal history is public safety offenses, batteries, robberies, batteries to officers, domestic batteries, the SBF with the handgun conviction, and invasion of privacy. He's a really high risk to reoffend. I think Mr. Britton acknowledges that the trajectory he's put himself on is a dangerous one. There have been past attempts to kind of change that. The state will note that the plea acknowledged the mitigating circumstances of being chased down and shot at and finding yourself in a difficult situation and still surviving. None of that mitigates the fact that he's not allowed to have the gun. He knows he's not allowed to have the gun. he continues to have the gun. It's kind of straightforward there. The state's requesting a 4-year executed sentence from the Department of Corrections.
Thank you, Steve. Mr. Hunt, anything you want to say, sir?
Yes, sir. I just really want to say that I accept full responsibility for my actions and I take accountability for what I have done. I did make a lot of mistakes as a juvenile. One was the biggest one, which caused me to be a felon. And I stayed out of trouble long enough where I thought I could get that expungement where I wouldn't have these situations. The law has changed now, but I didn't make it through it. Sir, I took steps to go to college. I got my OSHA 10. I made good construction courses, certificates. I just want to be a better man, sir, a better father. I didn't do my son's life too, but I actually just want to work on to being a law-abiding citizen and let my past be my past. I know I have that stuff as a teenager, for real, and I'm not trying to minimize my blows. I messed up, sir, and I realize that I'm done being a little boy, and I'm trying to be a grown man now and take care of what I have to take care of. That's really all I have to say.
Appreciate your thoughts, and I appreciate your attorney's comments too. Your choices have put you in a tough spot. Somewhat, and not that it excuses anything, but your circumstances have put you in a tough spot too. I mean, if you were sitting on bags of money, it'd be easy to pick up your family and go to a new location and start fresh without these people looking for you or any of that stuff. But, real life is we don't have those bags of money that you're sitting on. I get it. That's tough. And when you're young, you've got some strikes against you. You need a family support system around you to help you out. And your family support system's in the same area where the trouble is. That's kind of a thing that I understand. It puts you in a really bad way. You did have those bad choices and, that you made when you were younger. That was clear back in 2014. Here we are in 2026. So from 2014 to 2019, you had those things that we're all going through. You were discharged from probation in 2020 from that. And then just that same year, you had a domestic battery case. Then you had a case that was dismissed, but you ended up having a license case. Then in 2021, you picked up that first felon with a firearm case, resisting law enforcement vehicle and all that. And then you had an invasion of privacy and intimidation. It's not exactly one mistake that you made. You keep making bad choices, and these things are going to haunt you because your juvenile history and your adult history, those things are serious aggravating factors, and not just the fact that you have a tick mark in the felony or misdemeanor column, but just that even the nature of those things are disconcerting public safety offenses, as the state said. Mr. Britton, I think originally we had 162 days of credit allocated, but that was a week ago, so we bumped it up to 169. Is that accurate?
That was a note I had that I forgot to mention before, so I appreciate it.
169 now?
Yes, sir.
Okay. So you do have some, as your counsel mentioned, that you had a decent amount of credit coming in. You got 169 real days. So that's not an aggravating or mitigating circumstance, but that's part of the landscape here. You did accept responsibility, so that's a mitigator. However, the state also noted that was somewhat taken into consideration with regard to the plea. Knowing, of course, that this started as an F4 and was reduced to a 5, pursuant to the plea, which, you know, cuts the maximum exposure in half. Because net 4 is all the way up to 12 years. The max exposure on a 5 is 6. And not only that, but the plea agreement caps your initial exposure at 4, which is below that 6. So you're looking at a third of what you could have been looking at. So it's a pragmatic decision somewhat too, to accept responsibility here, because you really did limit your exposure. All of which is to say that there are mitigators there, including the fact that you do have a child, that are unfortunately outweighed by the aggravating circumstances. The court has to balance what's best for you with what's best for the community. And know that, you know, the other party to this whole mess, he's got a sentencing date coming up too. So justice will be done there also. But in this case, it's difficult to see, with especially with the prior gun charges and underlying issues, that community corrections has said no because of the history of non-compliance. It's just, we're not down to a lot of acceptable options. And the court does have to protect the community. So I think a 4-year sentence is the appropriate sentence here. That's Department of Corrections, 169 days of Class B credit. The weapon will be forfeit for destruction. I will waive all fines and court costs, public defender fees, because you are indigent. State, am I missing anything?
No, please, Your Honor.
Mr. Britton?
I don't think so.
Mr. Hunt, you know, you're going to come back to this community in a relatively short amount of time. I don't know what there's no easy answer for you. I understand that the deck is stacked against you here, and I understand that this is also where your support is, but you are a young man, and you seem like a resilient fellow, and you've got some gifts. You're a smarter guy than a lot of the dudes that you were running with, and I think you know that. So I hope that you're able to use those gifts and find a way out where you and your family can make a better life for you. Wish you well, sir.
I just want to kind of say, like, my mess up in community corrections was 8 years ago, sir. Like, can I get some type of suspended time? I mean, like, I'm not a danger to society, sir.
Maybe a year.
Your record says otherwise, Mr. Hunt. I'm sorry. Good luck to you.
Your record says otherwise, Mr. Harmon. I'm sorry. No, nothing for you. Okay, now this one. Is the lawyer confused or is the judge confused? That's what I want to know. I'm not going to say anything till you watch it.
All rise. St. Joseph County Superior Court is now in session. The Honorable Jeffrey L. Sanford presiding.
Right.
All right, I was wrong. The last guy we watched was David Francisco. And this guy we're watching is Judge Sanford. Because they just said it. So, this is Judge Sanford. Which is the exact same camera angle as Liz Hurley and Riggins maybe? I don't know. I can't remember now. But they change the camera angle every once in a while. But now we'll remember. I won't remember, but maybe you guys will.
Mr. Conway, what are we doing?
Mr. Conway would like to offer.
We're not deleting your messages. None of the mods and us are deleting your messages. YouTube just sucks.
Bishop.
Okay. Well, I'm just referencing paragraph 7 of the pre-filed diversion agreement, where it says that state filed an affidavit, did you not?
Yes.
And to believe the violation of the terms of the agreement has occurred, shall be admissible and shall be considered prima facie evidence that such a violation has occurred. So what you're telling me, Mr. Hosinski, is that you don't, since prima facie evidence, as you know, is available evidence, you're not disputing that affidavit. Is that true?
I would add, I suppose that would involve our admission this morning.
I'm sorry?
Our admission this morning is going to be the, violations related to specific terms of the individualized plan of action. Part of the
Well, okay, I didn't draft this agreement. I didn't sign the agreement. What the agreement says that under the plea agreement, not under the individualized plan of action, is that, paragraph 7, I understand that in the event the state has probable cause to believe that there's been a violation of any conditions, the state may file a written motion with the court requesting that it be terminated from felony pretrial diversion program and enter a judgment of conviction. They've done that. They filed a motion. The motion, the state shall set forth the place, the nature, and the alleged violations and the conditions upon which the entry judgment and position sentence will postpone. I understand that the court may issue either summons to appear or warrant for my arrest and will conduct an evidentiary hearing to decide whether a violation occurred. Then it goes on to say, agree and understand that such a hearing, a motion filed by the state setting for a probable cause to believe the violation of the terms of this agreement has occurred, shall be admissible and shall be considered prima facie evidence that such a violation has occurred. So, as I read it, again, I didn't draft this agreement, and I guess nobody seems to know what the agreement says, because nobody's ever bothered to read it. My understanding, sir, is that once the state files that, then you need to rebut those allegations. It's prima facie evidence that's happening.
and there is no rebuttal.
Do you agree with that state, or am I misreading it?
I believe your reading is correct, Judge.
I would be offended if you said it wasn't. So you think it's true. Okay, so you want to stand, raise your right hand, please. Sir, tell the truth, the whole truth, and nothing but the truth, so help you.
Yes.
All right. You know, did you understand what I was saying?
Yes, I did.
Okay. Did your lawyer explain it to you?
Yes.
All right. So the state back in December 8th of 2025 filed the following, alleging that you had violated the conditions of your agreement. The first allegation is that on about November 6th, 2025, we were charged with possession of marijuana and caused under 20 H01 2511 CM 8823. That matter is currently pending. Our issue was as of December 8th. On December 2nd, 2025, we were charged with domestic battery in presence of a child less than 16 years of age. Cause number 20 D01 2512 F6 1362. This matter is currently pending. And at that time, there was a warrant. I'm not showing a warrant on you right now. It was served on December 8th. So you're served with a warrant on you. owe $599 in court program fees and $670.68 in restitution, and has failed to make monthly payments towards the outstanding balances. The defendant completed his mental health substance abuse assessment and was recommended to complete the MRT program. As of this filing, the defendant has failed to enroll in his MRT classes, and the defendant has failed to complete his 30 hours community service. 10 of those 30 hours were due by September 30th, 2025. That's what the state is alleging. That is considered by me, pursuant to your agreement with the state, to be prima facie evidence that you violated the terms of your agreement. You have the right, sir, through your lawyer, to rebut those allegations. You're telling me you don't wish to challenge those allegations? Is that true?
Yes.
Do you need time to talk to Mr. Rosinski? We're not going to continue it to next week or something, but I'll give you time today to talk to him.
Yes.
Yes, what?
Oh, well, that's also.
Okay, well, you guys go talk. As I was saying, sir, the state has made these allegations and some to agree with the state. And although I would grant you that it's somewhat ambiguous, but I think that the motion setting forth or probable cause is prima facie evidence in those sense. It's a rebuttable presumption that you can rebut by introducing evidence to contradict what they're saying. But what you're telling me is that you wish not to put on any evidence. Have you talked to a lawyer at all about this?
Yes.
Well, I'm asking him, so since he.
Oh, we did have a meeting Monday that was scheduled. Charles called him Tuesday and Wednesday. Having him again call back then. We talked a little out there when I came.
Mm-hmm. So what do you want to do, sir? Because today's the hearing date.
Mr. Conway would like to offer admission to at least 3 of the specific violations.
He doesn't have to admit to anything. All he has to say is that I'm not challenging the motion that was filed by the state in the affidavit. It's already prima facie evidence. It's already proven unless you rebut it. I don't think you're getting it. The state has no burden in this case other than to present an affidavit saying that he's violated the terms of his probation or his pretrial diversion agreement. It's a rebuttable presumption because it's prima facie evidence that he violated the agreement. Now, you have the ability to refute that. So it's not a matter of making an admission. It's already proven unless you rebut it.
Mr. Conway would like to admit that he has not paid his administrative fees.
Sir, you're not getting it, sir. He doesn't have to admit anything because it's prima facie evidence. How many times do I have to repeat this? It's a rebuttable presumption that he violated those terms as listed in paragraphs 1 through 5. That he hasn't done that those things happen. And unless you refute that, I take it as prima facie evidence. That ends the hearing. So what I'm asking is, you're not admitting to anything. You're not challenging what was said. There's nothing on the record where you say, yeah, I committed this possession of marijuana or domestic battery.
Yeah, I don't rebut it.
Right, you're not going to present any evidence.
Yeah.
Is that right? And you understand, sir, that you've had the right to present evidence to rebut all 5 of these allegations. Say, you know what? This is not true because these things happen, right?
Right.
And you're walking away from that. You're not going to challenge that affidavit. Is that right?
Correct.
And so you would say that you violated the terms of since you haven't presented any evidence to rebut the allegations made by the state, you're saying, yeah, I violated the agreement.
Yes.
And you understand I have to treat this as a felon. All right. State? Any questions?
No question.
All right, I'm going to find, since the defendant has not rebutted any of the affidavit filed by the state in accordance with the agreement that he entered into it with the state, I'm going to find he violated his pretrial diversion agreement with the state and that he is now terminated from the program. And I'm required to enter a conviction as a felony today. That's what the agreement says, but I will ask for a pre-sentence report. So, sir, when's your next court dates over at Elkhart?
March 6th.
Okay, what's going to happen on March 6th?
I have a meeting with a lawyer in 2 weeks to discuss that.
Does your lawyer know that you now have a conviction for theft as a level 6 felony?
I have a court date today. I am going to call him.
You should tell him what's going on. So he's not.
Yeah, I am.
Okay.
I would just like to correct on the record. I've looked up Mr. Conway's case. It looks like that hearing is on March 9th, not March 9th.
Okay. Better to be early than late. All right. So, Mr. Ozinski, you're going to waive the 30 or you want to have sentencing before the 9th?
Ready to work. waive it, so.
Okay, March 12th for sentencing.
Very good, John.
So the lawyer started out, yeah, everything's revoked. Everything. He lost his deferral. He lost everything. Now he's a felon. The lawyer started out, I am not rebutting any of this. That's how the lawyer started out. I'm not rebutting it. And the judge went off on these tangents, you know, because when he said he wasn't rebutting it, the judge kept asking. So he's like, yeah, we're admitting it. He did it. He did the violations. We're here to say he did it. You don't have to say you did it. You just don't have to rebut it. Well, he said he wasn't rebutting it. He started off with that. So, yeah, that was miscommunications. The judge was just in a cranky mood.
Got cause numbers 2310 F5 363 2507 F6 695. One second, sentencing on both matters. Mr. Britton, are we ready to proceed with sentencing?
Yes, Your Honor.
Mr. Lane have an opportunity to review the pre-sentence investigation matters.
Yes, Your Honor.
And were there any corrections or additions that need to be made, sir?
No, Your Honor.
Okay. Then, Mr. Lane, what we'll do is we'll hear from your attorney. He'll make his argument recommendations, and we'll hear from the state. And then you'll have an opportunity to address the court if you'd like to. Okay, sir?
Yes, sir. Thank you.
All right. Mr. Britton, go ahead, sir.
Thank you. Thank you, Judge. Obviously the outcome of the Newer case, I think, is beneficial to my client based upon the terms of the plea. The larger portion of the exposure that he's looking at is the violation. I think originally it was a 3-year sentence for the time that he has coming to in that case. Since the pre-sentence investigation report was prepared, he has employment now. He's up through Forge staffing. So he's working, help take care of his family. It is otherwise being responsible in that regard. I think if the court looks a little bit back at the prior violation, he had a pretty rough turn with the house fire. And I think it was not only disruptive, but fairly traumatic for him at the time. Has most certainly mental health issues. Those are mental health issues that he has on and off actively addressed throughout his life, treated through Oakland. He says he's not currently in treatment, but he's actually still taking medication. So I would classify that as being in treatment, not perhaps the formal talk therapy type stuff. I think he's still actively engaged in that. It's something that I think that he would benefit more from. To help address the obvious ongoing issues he's had, and also probably more of the current issues that have manifested more recently in some of the trials and tribulations that he's experienced. Obviously the difficulty in this case, if it was just the newer case with misdemeanor, it's perhaps an easier path forward. The violation makes it a little more challenging prospect. I understand that Dugan even been eligible based upon previous violations. We would ask the court to consider an opportunity for him to continue in that placement violation to continue with the steps that he's taken more recently towards rehabilitation and stability. I think it would both benefit himself, but also his family. And we're asking the court to consider a probated sentence. The misdemeanor case is a step down supervision. Assuming he can successfully complete the remainder of the time of the violation, he can transfer to a probated sentence and continue with supervision, and hopefully continue with the trajectory that's on our.
Thank you, sir. State.
Give me 1 minute.
Hey, will you kind of laugh?
Give me 1 second.
Sure.
My YouTube just crashed. My YouTube just crashed, but it looks like the stream kept going. That's cool.
It's my understanding she left address the court.
Oh, I apologize. I didn't ask about this.
That's great.
Morning, ma'am.
Morning.
Please raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Go ahead, say.
Can you state your name?
Hannah Blackledge.
Ms. Blackledge, what would you like the court to know about what you think an appropriate sentence would be?
I think that, as you guys know, Genesis had a lot of, past previous, criminal history and stuff. But since, we've talked about it, we've had deep conversations, he's been active and being a father, being a better partner. I think that he benefits being at home, me mentally, him helping out. I kind of just, I don't really know what else to say.
One of the provisions of the plea agreement was termination of the no contact order. Is that on your request?
Yeah.
Anything else to say?
No, Your Honor.
Mr. Britton?
No, Your Honor.
Thank you, ma'am. Thank you for covering that, Mr. Wexler.
Yes, Your Honor. So starting off with, as far as the felony being pled down to misdemeanor, Ms. Blackledge's neighbor, which is known, I think the state is kind of in line with her as far as that when it comes to was now being entered as a misdemeanor, maybe the 12 months of probation term a bit, as term of the agreement would be to Mr. Lang's benefits. I think the more difficult part, Your Honor, is the PTR. I think there is kind of where we find the rubber meeting the road as far as Mr. Lang has pretty rough criminal history, both as a juvenile as an adult. 2 felony convictions as an adult. I believe both what would otherwise be felony and misdemeanor adjudications as a juvenile. Both MCC and St. Joseph County Community Corrections said they weren't willing to take him. They said while it is being entered as misdemeanor, the offense that he's pleading to is a crime of violence that does present a lot of concerns. Given all that, Your Honor, the state is asking that he serve his backup time in F5 3016.
Thank you, State. Mr. Lang. Thoughts, sir?
Yeah, I had the opportunity to apologize to him, but not to the court. I know I caught a case the day before I had court on the 29th, but I had court on the 30th. I apologize for that. I've never committed for domestic, so I don't put my hands on it. It was a stressful situation. As soon as I found it out before Christmas, Sean, I got a job. I kept a job before I caught the case. When I got PTR from Ducal, I got PTR for 5 rounds. 2 of them was for getting fired from a job. The first one was my first month in Ducal Center. I was at Subway and I just didn't pay for a sandwich that I ate. I'm on a job, I get a free sandwich. I just didn't scan my barcode. I could have, but I'm not making an excuse for that. The other 2 was for, no, it was 3 or 2.
Hold on, sir. Your Honor, I didn't steal that sub from Subway. I work there and you get a free sandwich. But you gotta scan it in with your barcode, and I just didn't scan it in. Okay. We all work or have worked in our lives. Is there any boss that would charge us with stealing a sub if we worked there and just forgot to scan it in with our little barcode? No, the boss would say, you gotta scan that in. Did you scan that in? Do you want me to scan that in for you? They wouldn't call the police and charge you with stealing a sub. Something's not adding up. This is the case that he picked up. This man was almost done with everything. He was following the rules. He was almost done with his probation and everything. And then this happened. A Subway sub.
was I went to pick up my daughter at daycare, and they didn't have me out on schedule, but every day the schedule was the same, you know? Like, they should have knew. They could have checked my last week's schedule and seen I was supposed to go. She's at work. I can't just leave my kids at daycare. It's a certain time they close, and I called them, and Mr. Dale, the senior case manager, approved it. But Miss White, I've had a problem with her even back in 2018 when I was in Buckham Center, because I was cool. I was friends with her son growing up, and she did not like that. She didn't like it at all. I got emails of me telling Mr. Dale that she was harassing me in the program. Honestly, I really don't want to go back to Buckham Center. I know they denied me. I know NCC denied me for getting PTR from Buckham. Another write-up was for getting missed a drop. I missed my very first CSAP drop. The very first time they scheduled.
So he missed a drop and she wrote him up for it. But she really has a vendetta against him because he used to fight with her son. So really it's her fault because she has this vendetta out. She's out to get him.
But it was on a Saturday. Monday through Friday is 6 to nighttime hours. Saturday they closed at 11:45. I didn't know that, but I still called Buckham and told them I would be willing to go there and take a drop. I don't do drugs. I don't drink. I'm a family man now. You know, I said that at my sentencing for the first charge I caught.
I don't do drugs. I don't drink. Okay, ready? Here we go.
I had a house fire April 2nd. Man, I'm just glad I didn't fall off the wheel, but after that happened, because I had previous house fire before that where I lost everything. So it's like, since this happened, man, that's not the.
I think he meant, instead of falling off the wheel, he meant falling off the wagon. Guess what that means? That means he both drinks? Probably. I mean, he definitely drinks. I don't know about the drugs part.
I know who I am. I know I have a bad past. Everybody can see that on paper. But the last 3 years since this case happened, Buckham kicked me out on house arrest. They weren't even supposed to do that. I was supposed to do 2 years inside of the Buckham Center. They kicked me out after 4 months because I did a perfect program. You can't even gain 23 points, but I did extra activity and they gave me 4 extra points. So I got 23 points within 4 months and they just kicked me out on house arrest. Did a perfect program on house arrest. They finally started writing me up. Right after I got my first write-up, or my second write-up, sorry, I caught the first write-up my first month in Buckham at my first job at Subway. I never caught no more write-ups until my first month after my house fire. After that, they wrote me up 4 times immediately back to back after that. It's like I told my mom, I explained to the case manager, I felt like when I had my house fire, I was still on house arrest. So they was always complaining to me about having to call them when I'm leaving the hotel. They was really mad at the fact that I was in a hotel on house arrest because they can't tell exactly where I'm at. And they was just always bugging me about it. Like, for instance, I'll get a call in the middle of the night. It'll wake me and my kids up and they'll tell me I'm not at the hotel. I'm at a Subway. Come knock on my door. I gave you guys my hotel number, you know? Like, they got so mad because how many times I was emailing them a day just so I wouldn't violate. I have them all printed off. I still do. All my emails and I sent Mr. Dale, I got approved. The last straw that broke the camel's back was I got fired from Genco, but I got pulled over the night before for my tail light out. And I called Mr. Dale early that next morning before I had work and I asked him, I said, look, I got work. I get off at 4 o'clock in the evening. I really can't go do nothing past that time because I got to go get my kids after work and then go back home on my house arrest. So I asked him, can I take the day off to go get my tail lights fixed on my car? He approved it. I had that email printed off. And so I took the day off. I called my job, called the call off number. I didn't know that it was the day before my probationary period was up. You got 14 days. I have already worked Monday to Friday 1 week and then Monday to Friday the next week. And I called off that next Monday. My probationary period was up that Tuesday. So they fired me for that. But when I went to Duckham and they was filing the PTR paperwork, Duckham Center said they had already sent it off. But Janko offered me my job back and Duckham wouldn't let me go to work because it was the week he was out on vacation for the 4th of July. They said that I couldn't go back to work until it had got signed off. But really, I felt like they was just doing that. They didn't want me to go to work because they was pushing through the PTR. They wanted me out the they wanted me out the program since I first started. Like,
they wanted him out the program, not the taillight not breaking the law with taillight, not stealing a sandwich, not calling off within your first 14 days of work. You're going to call off a day? I can't come in today? Are you kidding me? My children know better than that, and they are just not intelligent. Anyway, it's definitely this lady's fault, 100%.
They had a problem with me running from there before, and I made it known when I went to the program this time that when I went to the program, I told them I wasn't running. I had a cousin that I was in the program with, and we both absconded from there before. I just showed him a whole different entire program. My brother completed the Duke Center program before. Before this time, I didn't complete it, but I just completed it for real. And at the end of my sentence, they PTR'd me. I got a PTR literally 2 months after my house fire. I didn't catch no write-up before that except that sandwich write-up. But other than that, I completed all their O-line programs they put me in. I made it to the honor dorm. I was getting 12-hour passes every day. All I wanted to do.
I just think they believe this. If they say, I didn't do anything wrong except, in their head, they didn't do anything wrong because whatever follows, except that sandwich I stole, except me getting pulled over because I'm driving illegally, that doesn't count for them because they didn't get rid of for this or that. This is it. Except, so they think their record is spotless because you can't really count that one. You can't really count that. You can't really count them.
Would go home and be with my kids, and they pushed me out on the bed, and I did that. Since I've been out now, I don't even know if this was accurate or not, but the last time when I came to court, we dropped a no contact order. I asked them, I went to Dukem and asked them, Judge Dewey put the house arrest bracelet on my leg for the no contact order. So I called Dukem and I was like, they dropped the no contact order. Is there a way you could still take the band off now with the no contact, the GPS band? They wouldn't do it. And I told them, I said, so I'm getting charged the fee. It's still, and they just still was charging me. It's been a whole month and that's $100 now, like I just called them 3 days ago and they told me my fees is $490. I don't know how. I just want to be able to still continue working. I'm gonna be honest, I don't want to go back to Dukem, but I don't want to go to jail neither. I came back home. I'm taking care of my kids. I did 5 years in prison. I don't want to go back to the joint. I don't want to be in county. I just did 5 months in county. I just got reacquainted back with my kids and my household, The biggest thing I regret was catching that new charge the day before court. That shit still ain't unreal. You know what I'm saying? So it's like, man, I put too much hard work in to get sent back somewhere. And I'm not out doing wrong. I'm going to work. I'm taking my kids. Man, I just found out it's sledding. So it's like, I missed her first birthday when I just got locked up. I don't want to miss no. Man, my birthday was just 6 days ago. I don't want to miss no more birthdays, Christmases. I'm not out doing wrong. Man, I'm just doing what I got to do for my kids. That's it. Man. I really felt like I was going to get my PTR matter thrown out because I could pull my profile on my PTR matter. You can mess me around. But at the end of the day, I caught that in case. I know that. But I don't hit females. I'm not a violent person, period. I don't hit nobody. Let alone my girl.
I sometimes hit females.
I know people catch domestics, they hit their wife in the face. I smacked on her leg. It was a video of that. I showed the cop the video. It's not like they had to go force her to show her. I'm the one who provided the video. So it's like, man, I'm just trying to do what I got to do now. And if I got to go do my time, so be it. But man, that'd just be taking a father away from these kids now. We can see I could do time. You see, I don't want to do time. But I just don't want to keep running. I don't want to do no time. I'm a better man now. I'm just off for my kids. And I'm hoping to make them like that. That's all I can say.
Okay, thank you. So here's if your attorney says sticky or use the same, sticky wicket or something with regard to that F5 cause. I'd like to shape about the F6 695. You did serve a pretty substantial penalty there with 144 days credit earned in that one. Problem is on that F5 cause, you got 428 days towards a 3-year sentence. According to the credit time calculator, maybe that works out to 570 on the Class B credit total, which is a little over half of the sentence. Just taking you at your word, some of those violations seem pretty chippy, but you did pick up a new case. It's real. And that was in lieu of jail. That was, that was grace. I don't really feel like I have, given your criminal history, which is not insignificant, particularly your juvenile history. Or felonies.
Or I'm on the right track now.
I think you probably are on the right track. Here's the problem, though. You've made waves that are now crashing on your head. You know, the waves in the past are coming back to sabotaging. And that's not anybody else picking on you. That's you setting you up for failure. And that's a thing. I mean, there's a consequence for that. That underlying F5, those are some serious charges. And you were given grace.
Okay.
I send a lot of people to prison for those. You got community corrections time will good too. That's pretty generous. So what we're going to do on count 2 of cause number 695, your sentence is going to be 288 days. You served 144 days. Terminate the no contact order pursuant to the plea, even though I think it was already terminated. Make sure it's gone. And be discharged on that cause. Cause number 363, violation of placement. Irrespective of the credit time that you've earned, consequence for violating that is going to be another 180 days incarceration. Starting today, which is not even close to the full amount. But when you come out, you're not going back to Duke, you're going to probation. You'll do a batteries and retro program when you get out. So I don't want you to be the better man that you're trying to be.
But they don't like him on probation. Didn't
I
you
got
hear
one
him,
question.
Judge?
What's your one question, sir?
Man, I'm paying the bills. Is there any way that sentence could please be suspended? I'm willing to do everything. Y'all got my name back. Man, I got work in the morning. I'm really doing what I got to for my kids. And
I understand that. These wages you created in the past for crashing on your head. There's nothing there. There's no. You understand that I'm giving you a lot less than what's hanging over your head, right?
I do.
Okay. That's me trying to extend you grace and recognize that you are doing a lot of things right. There is a price to be paid.
You're out of lives, sir. Out of lives.
That's going to be it for you. An additional 180 days, you get credit time applied towards that as you earn it. I'm not saying 180 real. I'm saying 180 days of credit total, right? You understand what I'm saying?
Yes, sir.
And then you'll be released to probation. And as soon as you're released, you'll get signed up for that Better to Adventure program and finish the rest of that term on probation. Okay?
Yes, sir. Can I request one more thing?
You can make a request.
Manager, anyway, I could get my 5 o'clock so I get my affairs in order, get my kids, and tell my job that I'm not no flight risk. I prove that.
We're going to do it this way. On count 2, I forgot to say there's a $50. That's the violence fee. Other fees are waived.
I'm not no flight risk.
I know.
If I may.
Yeah.
Under 695, there's a significant bond that will be released. And it's
We'll apply
lower.
that to the domestic violence fee.
It's over 3,000.
Yeah, is that posted by him or?
I'm not sure.
That's probably
Mr.
why
Lane, would you like that?
I'm not a criminal, Jen. I don't have a record because taking care of the kids and paying the bills took up every single second of my life. I didn't have time to commit a crime. That's why I'm not a criminal. It's not because I'm different than him. It's just I didn't have time.
Balance of your bond released to Ms. Blackledge for your family?
Yes.
Smurf, I don't know why those cookies look delicious, but they do. Look, guys, look on the screen. Don't those cookies look delicious?
Anything I'm missing, State?
I don't believe so, Your Honor.
Mr. Lane, when you get out, there will be probation fees assessed. Those will come incrementally. It's a lot cheaper than home detention.
Can I give my wallet?
You can hand it to the officer here. He'll hand it to her for you.
Yeah, but they were committing the crime then, T. They were trying to charge me $21. That's robbery. Robbery.
Certainly, it's not a perfect resolution, but it's not the worst case. If you hadn't been doing all the things right, we're good. This is what you would have got, right? Once you do that. I don't take it lightly. I hate taking father away from his kids, but you kind of pushed me into the corner on this one.
Me too, Linus. Me too.
All right.
All right, guys. Thank you so much for coming out today. I really appreciate it. For a little bit of Indiana. I'll try to do Colorado tonight. I got a judge. She's pretty strict. And I have a little, so it's over an hour of her. And I'm wondering if I should play her tonight. She's really good, but I don't know if an hour is too long for one judge. We'll see. We'll see. I'll see some of you in a couple hours. The rest of you, I hope you have a great day. And I'll see you all tomorrow. All right? And I'm sorry that YouTube keeps eating comments. I don't know how to fix it, but maybe YouTube will. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my a joy she can't hide.